Anthropic just wrote a $1.5 billion check to settle a copyright lawsuit, the largest copyright payout in United States history. And the reason it matters to you is not the number itself, it's what this signals about how every AI company will source its training data from this point forward. Here's what happened. A group of authors sued Anthropic, the company behind Claude, alleging it downloaded millions of pirated books from shadow libraries like Library Genesis and Pirate Library Mirror to train its large language models. We're talking roughly 500,000 copyrighted works scraped from illegal repositories. In June 2025, federal judge William Alsup split his ruling in two. He said, training AI on copyrighted books you legally purchased is fair use, that's protected. But downloading pirated copies, that's infringement, full stop. Facing potential statutory damages that could have reached tens of billions, or by some estimates, north of $900 billion if willfulness was proven. Anthropic settled in August for $1.5 billion, roughly $3,000 per book. The company also agreed to destroy the pirated datasets entirely. Think of it this way. The court essentially told AI companies, you can read the book, but you can't steal the book. Buying a copy and scanning it for training? Fair use. Downloading it from a pirate site? You're writing a very large check. Now, why should you care if you're running a business or building with AI tools? First, if you're an AI developer or startup training your own models, the sourcing of your data just became a make-or-break compliance question. It's not enough that your model works. You need a clean paper trail showing where every piece of training data came from. Anthropic's settlement proves that pirated or improperly licensed data creates existential legal risk, even for a company valued at $183 billion. Second, if you're an enterprise customer using AI tools, this changes your vendor diligence. You now have a concrete reason to ask your AI providers, where did your training data come from, and can you prove it was legally acquired? Companies that can't answer that question clearly carry downstream risk that could affect you. Third, if you're a content creator, author, or publisher, this settlement establishes a financial benchmark: $3,000 per work. That figure will anchor future licensing negotiations and settlements across the industry. The Copyright Alliance called it a victory that emphasizes the need for AI companies to move toward a permission-based licensing model. But let's be clear about the limits. This settlement does not set legal precedent. It's a private deal, not a court ruling on damages. Other judges in other cases, like the ongoing lawsuits against OpenAI, Meta, and Microsoft, can reach entirely different conclusions. In fact, in the Cadre case involving Meta, a different court treated pirated downloads as part of Meta's overall fair use argument and ruled in Meta's favor. The settlement also doesn't cover future conduct. It releases Anthropic only for past actions before August 25, 2025. It doesn't create a licensing scheme for ongoing AI training, and critically, it doesn't address whether AI-generated outputs that resemble copyrighted works constitute infringement. That question, the output side, remains wide open. There's also a scale problem. $1.5 billion is manageable for a company that just raised $13 billion in venture capital. For smaller AI firms, paying $3,000 per work across hundreds of thousands of titles could be a death sentence. Several experts flagged that this dynamic could consolidate the AI market around a handful of players wealthy enough to settle or license at scale. So, what should you actually do in the next 30 days? 1. If you're training or fine-tuning AI models, audit your training data pipeline immediately. Document the provenance of every dataset. If anything traces back to pirated sources or sources you can't verify, flag it and consult legal counsel. 2. If you're procuring AI tools for your organization, add data sourcing questions to your vendor evaluation checklist. Ask specifically whether training data was lawfully acquired and whether the vendor can provide certification. 3. If you're a creator or rights holder, check the BART settlement website to see if your works are covered. The Authors Guild has set up a searchable database and a process to submit contact information for notifications about the claims process. 4. Monitor the U.S. Copyright Office's ongoing guidance on generative AI. They issued a comprehensive report around the time of this settlement, addressing pirated content and licensing frameworks. That guidance will shape policy in the months ahead. 5. Watch the pending cases, especially the New York Times versus OpenAI and the music industry suits. The outcomes there will determine whether $3,000 per work becomes a floor, a ceiling, or an irrelevant outlier. The bottom line, Anthropic's $1.5 billion settlement draws a bright line, not around AI training itself but around how companies acquire training data. The model is legal, the piracy is not, and every AI company, every enterprise buyer, and every creator now operates in a world where that distinction carries billion-dollar consequences. If you want to stay ahead of shifts like this, subscribe to AI Blueprint. We break down the AI developments that actually affect your business every week.